Hi, so what we're going to do is we're going to recap the first few weeks of A-level law. In that time, we focused on the criminal justice system, understanding how it works and understanding the key elements that are required for a person to be prosecuted of a crime. So there are two elements that the majority of crimes require. There is an exception called strict liability offences, and I have another video which explains about those. So in terms of the majority of crimes, the prosecution must prove that the defendant had an actus reus and mens rea for a crime. So those Latin terms basically translate to guilty act and guilty mind, the physical element and the mental element. So those things have to happen together at some point at the same time. So you must do a guilty action while having a guilty mind at the same time. So the guilty act can be done in a number of different ways, and it really depends on what the crime is. So there are some there are some crimes that are just unlawful, things that you are not allowed to do. So for example, speeding is an example of a conduct crime. So speeding is a conduct which is prohibited. You are not allowed to speed. Another crime is state of affairs, where you being something is illegal. So for example, if you are an illegal immigrant, just being an immigrant is enough to be guilty of a crime. You don't have to do any more than that. There are some crimes, a minority of crimes, that can be committed through an omission. Now, an omission is just a fancy term for failing to act when the law expected you to. So normally you're not guilty if you fail to do something. You're only guilty if you fail to do something, but the law expected that you should have, and therefore that has led to some sort of guilty consequence. So for example, you could have a statutory duty to act. So for example, stopping at a traffic light or giving a breath specimen. If you fail to do those, you've committed a crime. It could be that you had to act according to your contract. A typical example would be a lifeguard failing to save someone. It was their job to act. You could have a special relationship. The most obvious example of this is parent and child. Parents have a special relationship to act. So for example, feeding their children. If they fail to do that, that can be a crime. And along similar lines, if you volunteer to take on a duty. So for example, if you volunteer to be a carer and then fail to care for that person, that could be a crime. Public office requires certain people in special positions to act, like police officers. And if you create the danger yourself, so for example, in the case of R versus Miller, a squatter threw a cigarette down, which caused a fire. Now, instead of calling the emergency services, he just left the room. He created the danger, so therefore he had a duty to act and alert people, which he failed to do. So those things can be a crime. Probably one of the most common ones is a consequence crime. So the defendant must cause a particular consequence. A clear example would be murder, which we're going to talk about in just a moment. So in order to prove that the defendant's act or omission actually caused the illegal consequence, so for example, causing the victim's death, we have to prove both factual and legal causation. Essentially, there are 4 hurdles that must be passed or proven to show that what the defendant did led to the criminal consequence, like the victim's death. So the first test is called the but-for test. This is a very simple test which asks, but for the defendant doing what they did, would that thing have happened? So in the case of R versus White, for example, the man put poison in his mother's drink. The question was, but for the drink, would his mother have died? And in that case, it would have happened anyway because she had a fatal heart attack before she even took a sip. So in that case, he did not cause her death. We also have to make sure that there is a clear link, a clear chain of causation between what the defendant did and what happened to the victim. Now, that can be broken by a number of different things. So for example, it could be broken by a terrible, unpredictable act of nature or God, a weather event. It could be the act of the victim themselves. Maybe they did something silly and unreasonable in the face of what the defendant did. So for example, in the case of R versus Roberts, the courts were debating whether the girl was silly to jump out of the car in response to the defendant's sexual advances. Or it could be the act of somebody else. So we typically see this with medical treatment. So it could be actually that the defendant committed a wrong. So in the case of Jordan, for example, the defendant stabbed the victim. The victim was recovering well in hospital, and then a doctor came along and gave them a huge dose of an antibiotic they were allergic to. Now, that poor treatment was so bad, that was so substantial, that it was the main cause of death, and it broke the chain leading back to the original stabber. As part of that, we have the de minimis rule. So in legal causation, it might be that your conduct was a cause, but only a very, very minor cause. So in the case of Jordan, for example, the stabbing was actually a very, very, very minor reason that the person died. Yes, they were in hospital because they were stabbed, but actually the main overwhelming reason that they died was because of the doctor's poor actions. Finally, if relevant, we look at something called the thin skull rule. So this simply tells us that if the defendant does something and that victim happens to react worse or even die, whereas an ordinary person wouldn't, the defendant must take the victim as they find them and take the consequences. So for example, in R versus Blau, Mr. Blau stabbed a Jehovah's Witness who then refused a blood transfusion. Ordinarily, people would accept the blood transfusion and go on to live. So he argued it shouldn't be his fault that she died, it should be her own fault. And the court said that he had to take his victim as he found her, and therefore he was guilty of her murder. So we need to show that the defendant actually acted wrongly, caused a wrongful consequence, failed to act when they should have. At the same time as that, they had to have what we call the mens rea, the mental element. Now, the mens rea that is required for the crime will differ depending on what crime they are charged with. So for example, for murder, only intent will do. You must have intended to cause death or serious injury. Now, it could be that that was your direct aim. We call this your main aim that you had in mind. Or it could be something that we call oblique intent. So it wasn't your main aim, that perhaps was another crime. However, the extra consequence was virtually certain, and the defendant realised this. If that's the case, the jury can decide that they intended that too. So in the case of R versus Matthews and Elaine, their main aim was robbery. They threw the victim in a river to try and get away. The victim couldn't swim and they drowned. It wasn't their main aim to kill or cause serious injury, but it's virtually certain that if you throw someone who can't swim into a river, and the defendants realised this because the victim was shouting for help, so the jury said, although it wasn't their main aim, it was an indirect intent of their robbery crime. Some crimes, however, don't require intent. They might accept recklessness instead, and examples of that would be things like assault or battery. Recklessness is where the defendant realised a risk and they go on to act anyway. So it's not quite as strong as oblique intent, which uses the words virtually certain. I realised a risk, you should be expected to then avoid that risk, but you decide to go on and do it anyway, you can still be guilty of a crime. The final level of mens rea is negligence, which is normally a civil wrong. There are some crimes where just being negligent can lead to a criminal charge, like gross negligence manslaughter. So that is where you fall below the expected standard. That is what negligence is. And that leads to someone's death. As I said at the start, these two things have to happen at the same time. It's no good me wanting to kill someone and it doesn't happen. That wouldn't be a crime. Similarly, if I cause a consequence accidentally and I don't have any of these mens rea, that's not a crime. We do, however, have something called transferred malice. So what that means is if you intend to harm or kill one person, but you miss and harm and kill someone else, then what we do is we simply transfer the intent that you had for your original victim onto the new one. That's because the law says you intend to harm or kill someone. It doesn't mean your intended victim. So we can see an example of this with murder, and murder was the very first crime that we looked at in year 12. So we can see the application of the actus reus and mens rea. In order to be guilty of murder, you have to have these at the same time. So the actus reus, it comes from the Lord Coke definition from the 17th century, and it is the unlawful killing of a reasonable creature in being under the Queen's peace. So that is the guilty action. You must cause a consequence, a killing. It has to be an unlawful killing in unlawful circumstances, so not, for example, in self-defense. And you have to actually cause that death using the 4 hurdles of causation I talked about on the other side of this board. We must show that you factually and legally cause the killing of a reasonable creature in being. So that is a human being who's existing independent of the mother, so that doesn't include fetuses. And it is a person who is still alive. We count death as brainstem death. So once there is no brainstem activity, that person is counted as dead. As long as there is still brainstem activity, they are alive and you can be charged with their murder. For example, if you turn off a life support machine without authority. And all of that has to be done under the Queen's peace. So that simply means during peacetime. Rules are different in war. You can kill in war in certain circumstances, so it has to be in peacetime. When you do that, you must have the mens rea at the same time, or it can't be murder, though it may be a lesser crime of manslaughter. You must have had malice aforethought. Now, aforethought doesn't mean motive or premeditated. It simply means that it was something that you wanted to happen, that you intended to happen. So that means you either have to intend to kill, that's express malice aforethought, or you intended to cause serious harm, that's called implied malice aforethought. So if that happens, that can still be the crime of murder. Now, we also talked about the criminal justice system, and just a few final words on the offence of murder and how the criminal system works. The offence of murder is a common law offence. That means it's not made by an Act of Parliament. That means it was made by judges in courts and developed over time. It leads to a mandatory life sentence. So that means a charge of murder, a finding of murder, must be given a life sentence. There is no choice. You can't give anything lesser, like a fine, for example. They must be given a life sentence. The Crown Prosecution Service, the CPS, must prove to the jury, 12 ordinary members of the public, that the defendant was guilty of this, that they did this, and they must prove that beyond reasonable doubt. And think about what that means. There's no room for real uncertainty here. If the jury is going to prosecute someone, because that leads to a mandatory life sentence, they must be sure that they committed the actus reus at the same time as the mens rea. So that's just a really quick whistle-stop tour of the first couple of weeks of the things that we talked about. There is much more detail in your handouts, and there are also many more videos on our YouTube channel which break down these individual elements. So I hope you found that useful, and thank you for watching.